Thank you, Mr. President. I stand to make my very brief, Senator Gale, very brief contribution. Senator Gale and I had a little discussion this morning. No, but it's in fact very brief. My very brief contribution to this debate, the bill to amend the Trademarks Act. Senator Webley, you know, and I think I'm beginning to sound like a scratch record, but every time I stand to speak on anything to do with the creative industries, I always mention Vanessa James. And for those of us who practice in the creative industry, or shall I say, who used to practice in the creative industry, then we must know who Vanessa James is. And Mr. James, in his book, spoke about the impact of the creative industries on the economy of Jamaica. And he mentioned that if you invest $1, and I'm paraphrasing now, but if you invest $1 in the creative industry compared to other industries, then what happens is that you multiply that effect 5 times. And so when I heard you talking about the entertainers and the different practitioners within the creative industries, I am heartened because it is quite true that the creative industries really stand out among the contributors, or the very likely contributors to the GDP. The fact is that it has taken us so many years, so many decades in fact, to have an appreciation for the real impact of the creative industries. And we have been seeing some signs. I know we had the Copyright Act earlier, and we did the Patent Act, the Trademark. I know we are amending the Trademark Act to give effect to our own agreement under the Madrid Protocol. And all of these are steps in the right direction, and I can only hope that we continue there. But the fact remains, though, that there remains so much more that must be done for us to take full advantage of the creative industries. And it goes beyond just patent and trademark. If we go to perhaps, and I see the legal officer from the ministry here, and it goes beyond, if we look, for example, at perhaps the widest participants in the creative industries, who would be our entertainers and persons involved in the everyday copyright system, what is clearly lacking is a harmonization, a coming together, but also the required professional engagement that is required for us to fully have, for us to fully exploit that industry. I remember back in the days when I was much younger and thinner, I did a paper looking at the contribution of the, looking at how laws impact the contribution of the creative industries in Jamaica. And one of the things that stood out for me was the Copyright Act, which was quite new, and the whole issue of piracy. And even though we have this act, and we talk so much about piracy, we had all these ads on the media, you find that there was still a significant number of Jamaicans who were involved in burning CDs and burning DVDs. And that has not changed much, notwithstanding the cases that have gone to halfway through. It still hasn't changed. And, you know, depending on where you do your shopping or you do your other activities, it is not unusual for somebody to just come to you and say, you want a DVD for buy? And I'm like, do you know that it's legal, right? But the fact is that there's still so much to be done. But notwithstanding all those challenges, today is a good day for persons involved in the persons involved in the creative industries. And it is a good day because it is a step towards the right direction in terms of our quest for harmonization of what we do, and in particular in terms of the Trademark Act. You see, Mr. President, the fact is that we cannot operate in silos. Senator Webby spoke about his own experience being the chairman and CEO of an international company. And the reality, Senator Webby, is that the world has gotten smaller and smaller, and borders as we knew it have been eroded and have gotten less and less. COVID, in fact, is one of the things that have confirmed that international borders as we knew it then no longer exist. What has given rise is international trade. E-commerce is on the rise. And so matters of patent, matters of copyright, matters of trademark are becoming more and more important. And I agree with you that apart from passing modern and relevant legislation, as a country, we are going to have to find a way to educate, to inform, and to get compliance amongst our populace on these very important matters. And I want to also give support to you that while we pass these amendments today, that we also commit, and I ask the government to commit to a new and inventive public education campaign that will allow everyone to understand and to comply. Because some people understand, but they don't comply. And I'm hoping that as we continue, we will have a greater compliance rate. So, Senator Webby, you spoke about the importance of these amendments and the economic benefits, which again, I am in full agreement with you, that can derive. Because indeed, what it does is it reduces the financial burden on companies who no longer have to have a trademark in Jamaica, a trademark in the Caribbean islands, a trademark in the US, or a trademark in Africa, not looking at anybody. It reduces that. So what happens that you literally have a one-stop shop. But the other benefit of these amendments is the first file benefit that derives. In other words, if you, prior to now, if you file an application for trademark in Jamaica, and it is accepted and registered, then that protection is in Jamaica. If someone in Africa, for example, wants to use that particular trademark, there was no guarantee that the trademark you have in Jamaica would extend there. What the first filing does, or what the amendment does rather, is that it gives you that benefit of first file. So once you file in Jamaica, you don't have to rush to file in Africa. And if somebody in Africa, for example, seeks to file, or if there's a dispute rather about that same trademark in another country that is governed by the treaty, then the court will rely on the first filing to determine who really has the right. And I think that is a benefit that we must talk about. Mr. President, the bill has my support, but I want to just highlight a few sections for consideration. And I know, I regrettably, Minister, I wasn't here to hear your opening, but I did hear what Senator Webby said about the amendment to Section 12 at Clause 5, in terms of the amendment as to who or the use of the national symbols. And the present bill, the present act, has an absolute provision that they can't be registered. I wanted to understand, Minister, the reason why we have now changed from that absolute provision to a qualified position. My personal view, I really like the absolute. I like the absolute, especially when it comes to our coat of arms. I can understand some need for a qualified position in terms of the Jamaican flag, but when it comes on to the coat of arms and other symbols, I have an absolute preference, which is my preference is that it should be absolute. But I shall like to find out, it should be absolute, as in you cannot register anything using the national symbol, particularly coat of. And I would really want to understand the reason why there's a move now for there to be a qualified use of it. And also, you know, who gives in the operation of this? Who gives the permission for it to be used? I note it says that it shall not be registered unless the registrar is satisfied that consent has been given by or on behalf of the government of Jamaica. But who really gives that permission? Is it going to be the ministry of culture? Is it going to be coming from the OPM? Is it going to be coming from industry? Is it going to be coming from there's this body that deals with national symbols, and I can't recall that name right now. But who exactly will give this permission? And what heritage? Yes. Is it going to be coming from there? Who gives this permission? And what are the considerations to which this body will address its mind in giving the permission? So that is something that I have a little unease with, and I would be so grateful to have further and better particulars about it. Continuing at 1A, that's 5.1A, where it talks about where a trademark which is the subject of an application or registration contains the name of Jamaica, a map of Jamaica, or a national album, the registrar may impose a condition or a limitation on the trademark in the register to the effect that the goods or service for which the trademark is registered shall originate in Jamaica or in another country, as the case may be. I have a problem with that, Minister. And I tell you why I have a problem with it. If it were that we were saying that the permission to use these other things would be given if the trademark is registered if the trademark is registered or originates in Jamaica, then I could understand. But in another country, as the case may be, I have much discomfort. And I tell you why I have much discomfort. Some of which Senator Webby spoke about, clearly not in support of my point, but it is the exploitation that has taken place with our national symbols, with the things that are uniquely Jamaican. And I don't believe that we should encourage the use of the word Jamaica or Jamaican, or that we should encourage the use of our symbols for things that are not unique to Jamaica or things that have not originated from Jamaica. So, for example, we know there's no doubt that marijuana is a big sell now. And there is also an international acceptance that Jamaica marijuana is the best, and I'm not speaking from experience, by the way, but there is an international acceptance that it is the best. that is the best. But think about this, Senator Hill. Senator Hill, think about this. That, somebody, because they know, or even our Blue Mountain coffee, because they know the pull factor of the Jamaican weed or Jamaican Blue Mountain coffee, and they want to trademark it, they can easily just put Jamaica. It has nothing to do with Jamaica, not even the seed, whether it's the coffee bean or the ganja seed, did not come from Jamaica at minimum. So I see in a very clear way the real possibility of this being exploited, and I would want to state on record my own challenge in accepting that provision. I would be willing to accept if it were to stop at shall originate in Jamaica, or in another country, as the case may be. I would have much challenge in accepting that. And so, Minister, I look forward to a response when you speak in the closing. At clause 8, it really speaks to the operation and the procedure of the protocol in Jamaican in its incorporation. But clause 26A, which is being amended, C, speaks to, it says an international application may be filed with the registrar where the owner of the national application or national registration is a national of Jamaica, is domiciled in Jamaica, or has a real and effective industrial or commercial establishment in Jamaica. I have some discomfort, and I seek some clarification on the words, or has a real and effective industrial or commercial establishment in Jamaica. I stand to be corrected, but I don't recall seeing such language in any other piece of legislation, and I stand to be corrected. I do know, for example, that when we're looking at the Procurement Act, and we're trying to carve out a special treatment regime for small businesses, which are not uniquely Jamaican in terms of registered in Jamaica, we looked at how we can ensure that there was a close relation to Jamaica, and it's very, very clear in terms of how you make that determination. But the words a real and effective industrial or commercial establishment in Jamaica, in my mind, is not very precise, it's not very clear, and it leaves the opportunity for it to be interpreted very broadly. And the challenge I have with that is, how does one measure this real and effective industrial or commercial relationship or establishment in Jamaica? Because if a company, for example, were to establish that, or were to say it has this kind of relationship in Jamaica, then if you're an international company, then maybe a subsidiary, or at least registering it as a overseas company operating in Jamaica, because those are very clear and practical ways in which you can cite that relationship, you can establish that relationship. And to that extent, I would want some clarification from the minister as to why it felt it necessary, and I know the technical team is here, to add these words, and how exactly do you determine or interpret if someone has a real and effective industrial or commercial relationship establishment in Jamaica. Then we look at the issue of fees, and this is page 6, clause 2, 26A2. And it says that the application made under this section shall be in the form prescribed and accompanied by the prescribed fees. I have no challenge with that. The only thing I want to say is that in determining the fees, we have to, on the one hand, be very mindful that we do not set fees that will be a deterrent. I hear Senator Scott Motley in her presentation spoke about the negative financial impact it is having on our Caribbean colleagues who no longer have the bulk of work coming in. And so it is important that we set a fee that will not be deterrent. But at the same time, we must set a fee that allows for real income to come to the government, to JIPO. And I say that because one of the things that we must not be afraid of is to really levy where levy is to be done, particularly on international companies. In the US, for example, the US Patent and Trademark Office, Senator Braham, is one of the few government offices that have an income that can assist in the federal budget. And that is because they are not afraid to charge reasonable fees. I am told that just one part of the procedure for a patent application is 50,000 US. So I am hopeful that once we start working through the prescribed fees, that we will address our minds to all the consideration and in a very balanced way levy fees or charge a fee that will allow JIPO to be fully functional. And this is important, not only because it could assist the central government in terms of its budget, but also we spoke about the importance of public education. And JIPO is going to have to lead the way in public education. I mean, it has been doing a good job, but there is still so much to be done. And it can do more if it has its own funding, this can be a source of funding. And in addition to which, there are going to be, well, I don't know how JIPO envisions working through this, but I would surmise that certainly additional staff would be required to review and to examine these applications when they come in, to make sure that we are not just complying with the protocols, but that our own local laws are being complied, particularly those that are registered outside and Jamaica is designated. So it's very important. So we're going to need additional staff, and I believe that this could be a direct source from which we can have, we can engage such persons. The rest of the bill, for the most part, really is just harmonizing what presently exists. At Clause 26D, we talk about a 10-year, which is something that presently exists in our law. And I guess for harmonization, uniformity, we continue with that 10 years. I'm wrapping up, Senator. Oh, he's not in here, but I did promise him that I will not be too long. So I'm wrapping up shortly. At 61B, where it talks about the change in ownership, and I'm particularly delighted with the use of the word may as opposed to shall, and I'll read it. It says, where the registrar is notified by the International Bureau of a change in ownership of an international registration affecting Jamaica, the registrar may declare that the change in ownership shall have no effect in Jamaica. And I'm particularly delighted because what it does is that it gives the registrar freedom and flexibility to make such a declaration, and again, to own our laws, to ensure that whatever changes are being done outside of the jurisdiction, once it impacts Jamaica, that they are in compliance with our laws. And this is something that finds favor with me. As I close, Minister, I want to say that these amendments represent a step in the right direction, for all the reasons said earlier. But we have to ensure that as we move now to operationalize, that we not only give credence and adherence to the Madrid Protocol and rules, but that we consider international practices. So one of the things I know that has been impacting some of the larger countries, and I can speak with some knowledge of what is happening with the US, is that you have bad actors. And these bad actors, they go in, and it's not unique to US, but they go in, they get information, there's scamming that's taken place, people are given notification about renewal, and all kind of stuff. So it is important for us that as we expand, because I foresee an expansion taking place, that as we expand, that the requisite security is put in place to ensure that not just persons' information are protected, but that we build the confidence that Jamaica is indeed a hub, but a hub where information is safe, information is secured. And I think if we do this, then what will happen is we will have more and more countries, more and more persons coming to us for registration. It will transfer into economic, ready for this word? Kevin is not here, but I know Minister Haley, you're going to like this word. When you have more persons coming on board, it's going to transfer into economic prosperity. Shall I say it again? I know. Apparently, I got permission to use it before I spoke. So. but seriously though, what will happen is that there really is a direct economic benefit that is going to result from this. And Jamaica can only stand to benefit. So not only will we be harmonizing our local laws with the best practice, with the Madrid protocols, but we will also be, we will be incorporating international best practices and best standards. And with the proper security, with public education and the correct management, then I believe that we will definitely be the go-to country. And this is easy to foresee because Jamaica is really rich in terms of our cultural heritage, in terms of our copyright, and our creativity is unparalleled. So we do already have the foundation upon which to build, and our technical expertise. Again, I want to commend the work of JIPO. I have had several occasions to interact with them. And whereas I'm not looking at anyone, I just saw that my very dear friend is here as well, who I can pick up the phone and say, I have this IP matter, what do you think? And so, Dr. Goff, I thank you. And I'm not seeing her. I'm not sure if she's here, your ED. But the work at JIPO is really outstanding, and I really want to commend you. And I believe that the amendments here too will definitely put us in the right stead, and Jamaica will in fact be a force to be reckoned with in this regard. So with that, Mr. President, I believe that I was short enough, and I thank you.
Thank you, Senator Frazer Binns. And